In the High Court judgment that said that level 3 and level 4 of the lockdown regulations are unconstitutional and illegal and has therefore been declared null and void, except for a 2-week extension, I want to continue with the specific relief that was claimed. And the one private person and the 2 organizations, they were all interested in very specific things. And as I've discussed in the previous video, they wanted to challenge the fact that a state of disaster was declared to begin with, and then the next thing they wanted to challenge is the specific regulations around the Disaster Management Act, or the DMA, that was implemented at the time. So to carry on, the relief claimed in this application and matters ancillary thereto, and that is very important because the reasons why the Disaster Management Act implementation, why that relief was unsuccessful, was because of what is stated here. And that is why it's so important that when you go to court, that you use the correct angle of attack to give the judge the ammunition that he or she needs to be able to judge in your favor. The applicants claim the following relief, and it's paraphrased in part and summarized from the notice of the motion: that the national state of disaster be declared unconstitutional, unlawful and invalid. So they wanted to completely remove the state of disaster. That all the regulations promulgated by the minister be declared unconstitutional, unlawful and invalid. Okay? And then a very important one, because the judgment later has very interesting judgments on this next point: that all gatherings be declared lawful, alternatively be allowed subject to certain conditions. And this is why earlier I actually said that when this 2 weeks grace period is up, we can actually do a lot, and we need to make use of that. Okay? So that all gatherings be declared lawful, alternatively be allowed subject to certain conditions. So they've allowed the judge to declare what he would consider conditions that might be required for gatherings. That all businesses, services and shops be allowed to operate subject to reasonably precautionary measures of utilizing masks, gloves and hand sanitizers. Now here, in my opinion, they're making a mistake, because they're now dictating to the court what measures might be needed. But luckily the judge considered this. This relief was, however, only sought as an alternative and made subject to consultation with the Essential Services Committee contemplated in Section 70 of the Labour Relations Act. So there's basically 4 things that they were looking for. It must immediately be apparent that some of the relief claimed has, to a larger or lesser extent, either been overtaken or at least been impacted on by subsequent events. So over the time frame of this court case, many things happen, because things are very fluid during this state of lockdown that we're in. So the court fortunately did take this into account. These are the promulgation of the latest set of regulations signed by the minister and promulgated during the course of the hearing of this application, being the regulations published in government notice, and it gives the whole number, alert level 3 regulations, which added chapter 4 to the existing regulations. So the judge considered that new regulations had been published and he was willing to look at them. The applicants urged me to, in considering the application, have regard to the facts in existence prior to the date of hearing, but were constrained to concede that the changing of the factual landscape on the day of hearing would be relevant when any appropriate relief is to be formulated. In other words, what he is saying, that if level 3 changed to such an extent that it was acceptable to the court, that he then needs to consider that. He cannot just judge on level 4. Level 5 never came into the court application, just so that you know. So, I mean, there was no judgment yet made on level 5 in any court in the country that I'm aware of. I might add that this matter was initially set down by the applicants for hearing on the 19th of May. So this has been coming on for some time. I mean, it's about 2 weeks now since that they laid this down in the court, even although it was an urgent application. The minister was given an admittedly short time by them to deliver answering affidavits, which she failed to do. So she was given a limited time. This was an urgent application, and obviously for the good of the people, because you need immediate relief and action in circumstances like this. And because of that, the 2 weeks extension of the lockdown regulations doesn't really help any of us, but at least there's hope. But he said that the minister didn't have much time, and then she failed to supply affidavits. An extension was negotiated by the state attorney until the 22nd of May. Okay, so that was even longer, which deadline was also missed. Now, of course, Zana Dlamini Zuma has a record of missing meetings, just not caring about appearing in court and actually delivering affidavits like this. And this is no exception, which tells you how she actually thinks about the law and courts in general. After I'd ruled that the answering affidavit need to be delivered by close of business on the 26th of May 2020, it was eventually deposed to by the Director General in the Minister's Department of COGTA, authorized by the Minister to speak on her behalf. So she sent the Director General to speak on the Minister's behalf to the court, basically. A further issue of concern for me, namely the possibility of conflicting judgment due to a multiplicity of applications in different courts and at different times dealing with matters related to the same subject matter of this application, was confirmed in another affidavit filed on behalf of the Minister in an application for condemnation for the late delivery of the answering affidavit. So the Minister was using other court cases that you also had to respond to as an excuse for filing late. So this is where I said before, we all have a right as individuals to take the government to court, and I encourage people to do so, but it's probably better to do it as a collective, so that we don't have the same situation where the government can claim that everyone's taking them to court and therefore they have no chance to actually respond to everyone's claims. So a combined court case legally would be the better option, but it doesn't stop any of you from taking the government to court in your own personal capacity. I interposed to state that the condemnation application was not opposed, and in order to reach finality in the application, it was consequently granted. So the claimants in this court case didn't actually oppose the fact that the Minister took longer, and they accepted her submissions. 4 different such applications were identified in the said affidavit, being applications by Inter alia, the DA, AfriForum, and the Fair Trade Independent Association, all other court cases that were ongoing at the time, in all of which some of the regulations or parts thereof were challenged. So these are other court cases that are doing specific things or attacking specific things with regards to the lockdown and regulations. Okay, in all of which some of the regulations or parts thereof were challenged, as I've said before. It's interesting that these organizations didn't challenge all the regulations like it did in this case, which was a better way of doing it because the court declared all the regulations illegal. Neither the counsel for the Minister nor the State Attorney could enlighten me of the exact nature or status of these other applications, save to indicate that most of them are pending and due to be heard sometime in June 2020. So the judge couldn't really go on any of these other applications because they were still before the court and they weren't being heard at this given point in time. This lack of cohesion and coordination is unsatisfactory, but the multitude of regulatory instruments issued by different role players over a short space of time is the most probable cause thereof. So there were many people submitting many things to court, and this can be a problem for the judicial system now, as you can see, based on what the judge is saying. Another aspect that needs to be dealt with is that of an as yet unreported recent judgment by my colleague, and this is the judgment on by J. Nukircher in the matter of Mohammed and 2 others versus the President of the Republic of South Africa and others in a case also in the High Court. In that matter, an application to have Regulation 11B of the regulation, which predated the Alert Level 3 regulation declared to be overbroad, excessive and unconstitutional, was dismissed. the judge found that the restrictions then enforced constituted a blanket ban on religious gatherings to be neither unreasonable nor unjustifiable. So once again, that in that previous court case, what was brought before the court didn't help their case. You need to be very specific. They did not tackle the Constitution. They tackled the regulations with regards to gatherings, and that was the wrong approach. She further found that every citizen was called upon in the name of the greater good and in the spirit of Ubuntu to make sacrifices to their fundamental rights. Now, this a court can judge on, because the public, the general public, should to an extent decide that they will work together with government in a situation like this to save lives. But to what extent? And that is where this court actually got involved in the judgment and declared these regulations unconstitutional because they couldn't find merit for any of them. A judgment was, however, based on an application whereby the applicants therein asked for an exception to be made for them, who also accepted that the regulations were rational and a constitutionally permissible response to the COVID-19 pandemic. Now, how stupid can you be to actually go to court, say that you accept the regulations, that they make perfect sense, but you want the court to make an exception for you? I mean, I don't know what these people were thinking, but I mean, no judge is going to uphold or support something like that. The relief claimed in that application and in the current urgent application differ materially from each other. So the judge acknowledged that what was before him and what was before the other judge, that she had a different set of circumstances that she had to judge on. In addition, the facts on which the applicants rely on the present application are also different from those relied on before the other judge. The current applications also do not accept either the rationality or constitutionality of the regulations. So in this case, the applicants said that the Constitution and with regards to the Constitution, that these regulations are unconstitutional. They made that clear in their attack against the government. And therefore, this judge had the ammunition to actually speak out and then judge whether it was unconstitutional or not. And if you don't give the judge that opportunity with what you bring before them, then they can't help you. So remember that with regards to future court action. In fact, that is the very basis of their attacks. So this judge is saying that what's before him now, the very basis of what's before him is the fact that they're attacking the constitutionality, which is the perfect attack, and that is why it was successful. I find that the two applicants are sufficiently distinguishable that the issues in the present application are neither nor that I am bound to follow their judgment. I shall now deal with the current application you're under. So this judge would look at other judges' rulings and then decide, do I need to follow the same kind of judgment? And in this case, he is saying no, that what's before him is completely different, and that he can proceed to actually look at this current case on its own merits based on the fact that the constitutionality of these regulations were attacked. The Disaster Management Act and the Minister's conduct thereunder. Now, the Disaster Management Act is quite an interesting thing, and this part of the judgment is far-reaching because it actually looks at the minister's role in declaring a disaster. What the judge says here, the preamble to this act states that the act is to provide for an integrated and coordinated disaster management policy that focuses on preventing or reducing the risk of disasters, mitigating the severity of disasters, emergency preparedness, rapid and effective response to disasters, and post-disaster recovery. The Act established national, provincial, and municipal disaster management centers. So this shouldn't just be a national thing. The Act says clearly that you should be national, provincial, and municipal disaster management centers that actually deal with any disaster. In terms of Section 23 of the DMA, when a disastrous event occurs or threatens to occur, the National Disaster Management Center must assess the magnitude and severity of the disaster and classify it as a local, provincial, or national disaster. Now, this is where our Disaster Management Act, the DMA, starts to break down because it doesn't actually look at a pandemic. When you assess the size or the severity of a disaster, you know, you can see what has happened. You can look at the state of a fire or an earthquake or floods and then make decisions based on that. With this pandemic, the government couldn't know beforehand what the severity was, what was going to happen. They still don't know. So this act doesn't actually work for this pandemic at all. The nature and spread of the novel coronavirus causing the COVID-19 epidemic in numerous countries, having originated to all accounts in Wuhan, China. The judge is just referring to media accounts, okay, because he has no other evidence. Has received unprecedented media coverage since the beginning of 2020. So he is basing the reality of the virus and the disease that develops on media accounts because he has no other evidence before him. This is actually fascinating that a judge would use the media in a submission as evidence. The nature of the virus and COVID-19 need not be restated here and has been covered in other judgments in this division, notably the Mohammed case mentioned in paragraph 3.5 above. So he can use other court cases and parts of those court cases as relevant judgment for this specific case. And the widely publicized but as yet unreported judgment of my colleague Fabricius J. Now this is a very important one because I covered this extensively. Fabricius J. in the Causa and others versus the Minister of Defense and Military Veterans and of Police and others. In this division dated 15th of May 2020, the rapid proliferation of COVID-19 epidemics to 114 countries caused the World Health Organization to characterize COVID-19 as a global pandemic. So here he mentions the World Health Organization and that they declared COVID-19 as a worldwide pandemic. In announcing the declaration, the President of the World Health Organization inter alia stated the following with reference to measures taken to reduce the impact of the pandemic. So he now quotes the President of the World Health Organization. And I quote, "We know that these measures are taking a heavy toll on societies and economies, just as they did in China," he says. I don't know why I had to mention China. "All countries must strike a fine balance between protecting health, minimizing economic and social disruption, and respecting human rights." He says strike a balance between protecting health, minimizing economic and social disruption, and respecting human rights. Let me summarize it in 4 key areas. This is the President of the World Health Organization. First, prepare and be ready. Second, detect, protect, and treat. Third, reduce transmission. Fourth, innovate and learn. Which means that they don't actually know what on earth is going on, and people need to learn. It's a process, okay? And we can all agree to that. Pursuant to the above, Dr. Tao, in his capacity as a National Disaster Management Center on 15th of March 2020, after assessing the potential magnitude and severity of the COVID-19 pandemic, potential here, not what has already happened, but potential, not covered in the Act, remember, classified the pandemic as a national disaster in South Africa, as envisaged in aforesaid Section 23 of the DMA. Dr. Tao, in the notice published by him regarding the above-mentioned classification, also referred to Section 23 of the DMA, which when read with Section 26 thereof provides that the National Executive is primarily responsible for the coordination and management of national disasters, irrespective of whether a national state of disaster has been declared in terms of Section 27, which means you don't have to declare a national state of disaster to actually enact these actions. The applicants have not attacked Dr. Tao's assessment or classification. And this is important because if they did, they would have had a better chance of succeeding. Dr. Tao went further in his notice and called upon all organs of state to further strengthen and support the existing structures to implement contingency arrangements and ensure that measures are put in place to enable the national executive to effectively deal with the effects of this disaster. This is obviously a quote. Once again, the problem here is the applicants did not attack what Dr. Tao asked for. And this is what they should have done. And when I continue in the next video, then you will be able to see how it becomes clear that there are problems with our law and with the Disaster Management Act and the rights that the minister has taken upon herself during this pandemic.